We have a treat for you today. Our speaker is Claire Guthrie Gastañaga, and she has an extensive background in government work and advocacy work here in Alexandria. And there's really nobody better equipped to talk to us about the ballot box and voting rights and the subject of today, governing access to the ballot box. Claire has her own company now. It's a consulting company called Change Servant, or changeservant.com is the website address. And but she has an extensive background both in government work and then in nonprofit work relative to government work. She was the executive director of the Virginia ACLU for 9 years. So that's pretty significant. And then also she was the first woman chief deputy attorney general of the state of Virginia. She knows the players, she knows the politics, she knows the vibe in Virginia, and can kind of be an effective advocate for causes, the key one right now being the access to the ballot box. So without further ado, I'd like to introduce Claire. Claire?
Hi, Louise, and good afternoon to everyone else who's joining us on this holiday. I'm so honored that you would choose to be here, and I'm very pleased to be able to participate with you today in this, what I hope ultimately will be a bit of a discussion about governing access to the ballot box and what is going on in Virginia right now and what has happened in the past. So as we celebrate President's Day, we have to talk about justice. Justice in our schools, justice on our streets, justice in our jails and prisons, and of course, justice at the ballot box. And you can't talk about justice at the ballot box unless you recognize the injustice of Virginia's history of overt, substantial, and violent discrimination against Black voters as a group and individually, and the efforts to govern access to the ballot box by people determined to prevent civic participation by Black Virginians. Virginia has a long and sad history of using every means available to deny its Black citizens the right to participate in the political process and to vote. Following the Civil War for 3 decades, Virginia's Constitution provided for universal suffrage, for men anyway, and Virginia sent an African American to Congress in the last decade of the 19th century. But at the end of the 19th century, the turn of the century, Virginia joined other Southern states in a concerted effort to disenfranchise Black voters in the post-Reconstruction period. Those leading the rewrite of our Constitution at the turn of the century said explicitly that their paramount concern was the disenfranchisement of African American voters. A subcommittee later studying repeal of the poll tax that was included in the 1902 Constitution said it this way: when the 1901 convention, I'm quoting, decided on the present voting qualifications, the reason which seems to have prevailed with the majority of the members was the belief that Black people had to be excluded from suffrage. In accordance with this belief, the 1902 Constitution conditioned voter registration on the payment of a poll tax, the unaided completion of a written application, and the ability to answer questions regarding an individual's qualifications as an elector. The enabling law gave registrars unfettered discretion in judging whether an individual was qualified to vote. And some registrars, according to this report from 1941, some registrars frankly admitted that they acted on a general principle never to register a Black person or a Republican. In Virginia, the effect of the constitutional provisions was to reduce the number of people who were qualified to vote who were Black. In fact, in fact, the data showed that the poll taxes, literacy tests, and other things included in the 1902 Constitution reduced the number of Black voters in Virginia at that time from 147,000 to 21,000. And so when as an aside, and another note, this same opposition to voter participation by Black Virginians was also cited by the same subcommittee as one of the reasons why the Virginia General Assembly refused to ratify women's suffrage. We didn't have ratification of the women's suffrage amendment until 1953, long after, obviously, it became effective. But the reason was that folks were concerned that Black women would qualify to vote in larger numbers. And so giving women the right to vote wasn't seen as something that could be done without also expanding participation of Black voters. So if you fast forward to 1957, I have a quote from Martin Luther King that when he gave the speech that's called the Give Us the Ballot speech at the prayer pilgrimage for freedom in 1957, he said, and some of the language in that speech is incredibly prescient and salient even today. He said, "Give us the ballot and we'll transform the salient misdeeds of mobs, bloodthirsty mobs, into calculated good deeds of orderly citizens. Give us the ballot and we will fill our legislative halls with men," I mean, he used the word men, "of goodwill." So he talked about what could happen. In fact, despite, unfortunately, his entreaties to give us the ballot, the poll tax remained in Virginia until abolished in federal elections by the 24th Amendment to the federal Constitution, and invalidated in state elections by passage of the Voting Rights Act of 1965. And passage of the Voting Rights Act of 1965 was done over the vigorous opposition of our Virginia representatives and congresspeople at the time, including the then chair of the Congressional House Rules Committee, Howard Smith, who said, quote, it was an, quote, unconstitutional vendetta against the former Confederate states. But passage of the Voting Rights Act in 1965 didn't end formal efforts to suppress Black political influence in Virginia. In fact, it spawned a number of efforts to continue the suppression of Black vote despite the change in the federal law. Our legislature first went to residency certificates, and then multi-member districts, and then various redistricting plans, up to and including the 2010 congressional plan declared unconstitutional, all of which cracked, stacked, or packed Black voters into districts in order to reduce their growing political strength. One issue live today is whether the Virginia House should run in the new census-informed districts just approved in 22, that were just approved by the Virginia Supreme Court, whether they should run again, having run in the old districts in 2021, run in the new districts in the new redistricting plan in 2022, and again, run in the new districts in 2023. This is what happened in 1980 after the 1980 census and the finding that the then multi-member district approach was unconstitutionally suppressing Black voters. Our House of Delegates ran in 1980, 81, and 82. So it is an unprecedented, and there is a court case pending in federal court that will determine whether our House will run 3 years in a row. The Senate will run in the new districts when they next run, which is in 2023. So in addition to all of those things that were directly focused on disqualifying individual Black voters, Virginia, as did many other southern states, implemented the felony disenfranchisement laws. These were mostly codified post-Reconstruction, and they explicitly targeted African-American, potential African-Americans voters to diminish their electoral strength. And those efforts lingered while other efforts to suppress the Black vote were swept aside, and legal challenges, at least until the Shelby case and some of the more recent Supreme Court decisions. The felon disenfranchisement provision in the Virginia Constitution is entrenched in this Jim Crow history and Jim Crow era racially discriminatory laws and policies. Like poll taxes, literacy tests, or so-called grandfather clauses, all white primaries, and such, felony disenfranchisement laws were intentionally manipulated during Reconstruction to exclude African Americans from the political process in Virginia, and their impact continues today. According to the Brennan Center, a Brennan Center report on racism and felony disenfranchisement, quote, before the Civil War, most states already had some form of disenfranchisement on the books, but these new laws were significantly broader, imposing disenfranchisement as a consequence for all felonies, rather than only a few select crimes like murder. In rapid succession between 1865 and 1880, at least 13 states, more than a third of the country's 38 states at the time, enacted broad felony disenfranchisement laws. And once those broad disenfranchisement laws were on the books, politicians could also enforce them in a discriminatory manner. For example, in 1876, Virginia broadened its felony disenfranchisement law to encompass petty theft or petty larceny, a crime of which white politicians believed Black citizens could be easily convicted. The next year, the legislature passed a law requiring that lists of voters convicted of any of the new broader array of disenfranchising crimes be delivered to county registers. And this is at the same time we had things called the Black Codes, in which there were specific crimes that only Black people could be held accountable for violating. These laws were all applied almost exclusively to the detriment of African American voters, and the law facilitated politicians' attempts to selectively enforce disenfranchisement. A Richmond-based newspaper at the time advertised, "We published elsewhere a list of, quote, Negroes convicted of petty larceny, advising the Democratic challengers should examine it carefully so that they would take into account who they might exclude from the rolls." And Virginia remains to this day one of the worst states in the nation for felony disenfranchisement. We are one of two states that have permanent disenfranchisement. In Virginia, if you are disenfranchised because you're convicted of a felony, and let me tell you, we've made so many things felonies now that it's, if you steal a $5 chicken, that's a felony. If you make a misstatement on a state application for a job, that's a felony. So we have so many felonies now. If you get convicted of any felony, no matter how insignificant, you are permanently disenfranchised unless a governor, a particular governor, chooses to give you that right back. And right now, this is a picture from the Brennan Center report on Locked Out, which was published in 2020. We have over 360,000 people in Virginia are disenfranchised because of felony convictions currently. Of the percent of the disenfranchised who are Black is 52%. Our state population is about 20% Black. And of the Black voting age population, almost 16% of Black folks in Virginia are disenfranchised. That is complicated by the increased racialization and felonization of the criminal legal system and longer sentences that have been imposed as a result from the mandatory minimum that's built into our no parole law. And this has increased the adverse impact on Black Virginians of the felony disenfranchisement provision. Now, governors in Virginia who have the complete and total authority over reenfranchisement have made a lot of things happened over the last 5 administrations, starting with Kane and Warner, and then through McDonnell and McAuliffe, and then Northam. Governors have, who used to only restore votes very rarely after a long and arduous individual application process. Over those 5 administrations, the process went from that very onerous individualized process, available for the most part only to a very select few of people whose felony convictions were deemed somehow to be less more acceptable, if you will. And so, for example, there was a time in which all drug crimes were classified as violent crimes, and governors Tim Kaine and Mark Warner wouldn't consider people who are convicted of drug crimes in a more expedited process that they were applying to nonviolent crimes. During McAuliffe's administration, McAuliffe started treating all of the applications for restoration the same, regardless of the crime that someone was convicted of, and even pushed it further to say that he wouldn't require people who are applying for restoration to have paid off all of their fines and fees and their restitution. So cumulatively, the last two governors, after the average used to be 5,000 or 6,000 people a year, the last two governors restored the rights of more than 200,000 people. So we used to have over 500,000 disenfranchised people in Virginia, and now we have about 360. But there's a really disturbing reality attendant to the increase in mass incarceration and the longer sentences after the enactment of the no parole law in 1995. In 1995, Virginia essentially created a mandatory minimum sentence for every crime by saying anybody who's convicted must serve 85% of the sentence that is applied to them. So that's a mandatory minimum for everybody. So everyone who's been convicted since January 1, 1995 is serving in prison longer. They're not eligible for parole, so they can't get out earlier, and they also have these longer minimum sentences. These developments have had a discernible adverse effect on and disproportionate effect on people of color. And let me show you some of the data. Interestingly enough, in 2016, when Governor McAuliffe tried to do restoration by executive order, he was criticized and ultimately sued by the Republican leadership of the legislature for having done this. They were arguing he'd done it because he wanted to qualify Black voters to vote for Hillary Clinton. And to defend himself, McAuliffe put out data to show just exactly who was included in his block restoration. He ultimately was told that he couldn't do this by an executive order, but he went ahead and restored the rights individually of 170 some odd thousand people from this group by signing the restorations one at a time. But look at the data that that Governor McAuliffe put out. So who benefited from the 2016 restoration? According to Governor McAuliffe, 51.5% of the people who benefited were white, and 45.9% of the people who benefited were Black. Now, 52% of the people minimum that we've estimated are disenfranchised are Black, but they didn't represent a majority of the people who got their rights restored. Similarly, if you look at the age distribution, you have some people at the lower end, but most of the people who got their rights restored were in the 40 to 60 range, all of whom would have been convicted. Average time that people are convicted of felonies is more likely to be in their early 20s or 25. So those folks would have been people who'd served 25 years or more. And so they were ready, they were already out of prison under shorter sentences. And then the distribution between people in violent and nonviolent crimes, the 80% of the people who got their rights restored were in what were called nonviolent felony categories. So that would be, things like perjury, embezzlement, but not anything that was, like burglary or something that was considered a violent offense. And so again, the way that the criminal legal system works and the disproportionate number of people who are classified as violent offenders who are Black, you can see why we were in a situation and circumstance where not everybody was benefited from restoration equally. So the question then becomes, what is the solution? Because if the solution isn't restoration, and obviously Governor Northam restored about probably 30, well, somewhere less than 30,000 people a year, but 12,000 more people were felonized and sent to prison. So restoration is never going to catch up and get us to the place we need to be, where we don't have a majority or we don't have such a huge proportion of Black voters who are disadvantaged by disenfranchisement. So there's only one solution to this. There's only one solution that results in true racial justice at the ballot box, and that's a constitutional amendment that removes the lingering vestige of the Jim Crow era, the felony disenfranchisement provision, and states once and for all that voting is a fundamental right. And a resolution was introduced in the last General Assembly session. In order to get a constitutional amendment passed, you have to introduce a resolution in an odd year, have an intervening General Assembly election, and then have it passed again in the even year before it can go to ballot. So this resolution was introduced in 21. There was an intervening election, and it could go to the ballot in 2022 if the legislature sends it there. Now, what came out of the legislature in 2021 wasn't everything I had personally hoped for. It wasn't everything I personally had hoped for. I wanted to see us get an amendment that truly was a guaranteed right to vote for everyone. And instead, we got an amendment, which I'm going to show you the language of in a minute. We got an amendment that says there is a guaranteed right to vote, which is a good thing, but says that you can't exercise that right to vote while you're incarcerated for a felony. The way the language is crafted, it does do a good thing. And the good thing is that it says that every person who meets the qualifications, which are a citizen of the United States, 18 years of age, and a resident of Virginia, that every person who meets these qualifications shall have the fundamental right to vote in the Commonwealth, and such right to vote shall not be abridged by law. And that's really good news, because the reality is that we don't currently have in our Virginia Constitution, and frankly in the federal Constitution, we don't currently have anything that's that explicit about the right to vote. And so here's the language. Qualifications of voters, this is in the current Constitution. In elections, qualifications shall be as follows: citizen, 18 years, residency. And then this is new language. Every person who meets those qualifications shall have the fundamental right to vote in the Commonwealth, and such right shall not be abridged by law. That is really good, because that then also puts up a barrier to future legislation that seeks to constrain the right to vote. But there is an exception, and I view the exception as being unfortunate because it leaves about 35,000 people behind. And you go on to the next, and it says that except no person who's been convicted of a felony, any felony, doesn't matter what it is, shall be entitled to vote during any period of incarceration for such felony conviction. But every such person upon release from incarceration and without further action shall be invested with all political rights. So the bad part of this language is that if you're in jail or prison because you got convicted of a felony, while you're in jail or prison, you cannot exercise your, quote, fundamental right to vote. But when the bars are no longer in front of your face, this language makes clear you can go the day that you get out of prison, you can go directly to the polls and vote without asking anybody's permission. And that's a good thing. Plus, upon release from incarceration and without further action means that it isn't going to be like Florida, where they thought they had gotten their right to vote back for anybody convicted of a felony, but then they left some of the language a little unclear, and the legislature promptly said, yeah, but it doesn't apply to anybody who hasn't paid all their fines, fees, and their restitution. Under this law, combined with the can't be abridged language, I would argue that that can't happen in Virginia under this language. So that's a good thing. The other thing that this provision, this constitutional amendment does, which is really important, is we have language that is also Jim Crow era and also eugenics era language that says currently that no person adjudicated to be mentally incompetent shall be qualified to vote until his competency has been reestablished. Now, we've learned a lot about developmental disabilities, particularly over the years, and we all know now that not everybody who's has a particular developmental disability is mentally incompetent or unable to understand the act of voting. And this kind of language in Virginia and other states particularly has resulted in hundreds of thousands of autistic people across the United States whose parents and families, without knowing the consequences, have had them adjudicated mentally incompetent and had a guardian appointed, not understanding that that automatically means that the person loses their right to vote. And in 2007, New Jersey flipped the presumption, if you will, and adopted language a little bit like this, which says, you can't lose your right to vote unless a court has made a specific factual finding that you lack the capacity to understand the act of voting. Not that you can't balance your checkbook, not that you might have some other legal disability that should be, should result in a guardianship. No, the court has to say you lack the capacity to understand the act of voting, and that will protect lots of people with developmental disabilities from losing this fundamental right to vote. And that's really important. So there is ample reason to support the passage of this amendment by the legislature and then by the voters in the 2022 election. Now, Senator Mamie Locke introduced the resolution that passed last year and passed both houses, and it's already passed the Senate this year. And it's called SJ1, Senate Joint Resolution 1, and it is now pending in the House of Delegates. Now, the House of Delegates killed a similar provision introduced in the House by a number of people, Delegate Herring among them. And they sent that to a subcommittee that met at literally at 6 o'clock in the morning on a Thursday and killed, and 6 people on that subcommittee voted not to report that bill to the floor. Now, lots of folks in the advocacy community truly believe that if the resolution gets to the floor of the House, it will pass. And so right now, the principal advocacy focus, and I'll talk a little bit in a minute about how you can be an advocate for this, the principal advocacy focus would be on trying to get the House leadership, the Speaker, the Majority Leader, and the Chair, and the members of the Privileges and Elections Committee to vote the Senate resolution out of the House committee to the floor for a vote of the entire membership of the House of Delegates. It is not unusual, unfortunately, for games to be played on issues like this and for things to be killed in a subcommittee that the leadership doesn't want to put to a vote. But it's time for us to really put pressure on the House leadership, particularly, to vote this resolution out. Now, I wish I could tell you that that was the only issue related to access to the ballot box that you should pay attention to. And I can't tell you that because that's not the case. Here is a list of all of the bills that passed the House of Delegates that are now pending in the Senate that would roll back changes that have been made in Virginia laws that moved us from being 47th in the nation in access to the ballot box up to 12th in the nation in terms of ease of access. So two bills would, and HB 46 actually includes a number of these provisions. It's sort of a comprehensive, inclusive bill, but HB 46 and 1090 both would reinstitute government photo ID as a requirement to vote. 39 and 46 would reduce the in-person absentee voting period from 45 days to either 14 or 21 days. HB 177 would impose stronger witness requirements for absentee ballots. One of the things we learned as a consequence of COVID is that another one of these Jim Crow era things, which is to require a witness on an absentee ballot, was really problematic for people who lived alone or were in quarantine and who didn't want to interact with another person. And this would not only restore the witness requirements, but make them more stringent than they currently are. There was a move to change absentee lists from having to apply every year to having a permanent absentee list. That would be repealed. There are two bills, 34 and 175, that would repeal drop-off boxes for absentee ballots. We're supposed to be getting same-day registration where you can walk into a polling place and register and vote on the same day, effective with the fall election in 2022, this fall, and there's a bill to repeal that. And we expanded the deadline for absentee ballots to say that they didn't have to be in by the end of voting on election day. They could be there by no later than noon on Friday, that they had to be postmarked by election day, but they could be received up until Friday at noon after the election. This would go back to, they have to both be postmarked and received on election day to be counted. All of these things are about rolling back things that were loosened to allow greater access to the ballot box and expanded participation. And the fact that they worked is evidenced by the really large turnout that we had in the 2021 election. And why, especially given, who benefited, most of these, every one of these bills was introduced by a Republican member of the Republican House Caucus. Why, after the turnout in 2021 and the results, they would want to shut the ballot box down again is hard for me to understand from either a moral position or a politically pragmatic one. So it's up to us to try to make things turn out right during this General Assembly session. And the way we're going to do that is we're going to take action. And here's what we're going to do to take action. We're going to find out who our legislators are if we don't know, and you have a senator and a House member, and you should be building relationships with both of them. You're going to check out the House Privileges and Elections Committee and see if either of your members is on that committee, but you're going to communicate with all of them, indicating you want to vote on the floor on the constitutional amendment. You're specifically going to target the Speaker of the House Majority Leader, because they're the ones who are going to pretty much direct the House Republican caucus about what's going to happen to the constitutional amendment. But you're going to want to touch base with House Minority Leader Eileen Fillercorn to make sure that she's aware of what your expectations are with respect to voting. And then you're going to want to be talking to the chair of the Senate Privileges and Elections Committee, Adam Eben, who is an Alexandrian, about how important it is to kill all those House bills that's on that other screen that I showed you. That all of these bills are going to go to the Senate Privileges and Elections Committee, and all of them there were similar Senate provisions that were offered with respect to some of these. There were parallel provisions, and none of them got out of committee. And you would hope that none of these would get out of committee. So in addition to doing action personally yourself, it would be good to talk to organizations that you're a part of and to try to engage them too in being advocates. Now, a lot of folks will say, my organization is a 501c3 and we're a charity and we can't do advocacy. No, they can't do partisan political campaign work, but they can do advocacy. And many nonprofits now are really making sure they understand how they can become engaged in advocacy. And Boulder Advocacy, which is a really wonderful group, has a whole tool that can be used to assess the capacity of an organization to engage in issues. And look, the right to vote is an issue that affects every organization, because who is voting is going to help determine what gets considered in the legislature, because the people that get elected are going to pay attention to who their voters are. And so if they know that Black people are disproportionately underrepresented in their voting, then they're not going to be as conscientious about issues of concern to the community. And then, in addition to thinking about how the organization could be a more effective advocate, I always like to sort of offer a few hints about how we each individually become more effective in advocating for our issues. And one is to find the allies, with the NAACP, the League of Women Voters, the Coalition of Latino Organizations, all kinds of different organizations. The New Virginia Majority are concerned about the right to vote. And you should find them and seek to build. Who's the opposition? The opposition is people who think that they do better when fewer people vote. But there are people who are going to be, concerned about people who got out of prison being able to vote, who were convicted of serious crimes. But most Virginians are not on that side of the issue. The group of people that, according to polling I've seen, about 30% of Virginians think people should be permanently disenfranchised based on having been convicted of a felony. And it's important, as you think about things, to center the people who are most impacted. So find the folks who in your community who are directly impacted by being denied the right to vote. And then, really understand the legislative culture. And, unlike the Hill, unlike Congress, you can talk directly to members of the House and Senate in Virginia. You don't have to go through a staff person. It's important, if you're going to do long-term work, to really understand the rules, but mostly it's important to prepare so that you know what case you're presenting and why. And there's lots of information there's a really great, on the General Assembly site itself, there's a long piece on citizen engagement at the Virginia General Assembly that's really good. Boulder Advocacy has a lot of work, and I've got, on an old website of mine, I've got 10 tips, and some of the things that you've seen on these slides come from that. But it is really important to keep these things in mind. And I watched something today, which is instructive. There was a person presenting a position in the Senate Judiciary Committee, and he got a little testy with the committee. They asked him a bunch of questions, and the questions they were asking him were meant to provoke him. And he got provoked, and then Senator Norman announced that to the advocate that he was going to be voting no on the bill that the advocate was against, but because of the advocate's attitude, he was now going to vote in favor of the bill. And that's, I mean, it's probably the case that he would have voted no anyway, or yes anyway, but you never put yourself in a position where the way you present your arguments undercuts the ability of the audience to accept your arguments and support you. Want to conclude just by, reminding us all that the right to vote belongs to the people. It is the only just basis for self-governance. It's how we decide who governs us. We shouldn't be in a position where the people who are elected are deciding who elects them. We should have the ability to decide who we want to represent us. And when government denies the right to vote to anyone, bottom line, it tells those individuals that they are lesser Americans. When people are told that they are less than full citizens, it hinders rehabilitation. If we want to rehabilitate people convicted of crimes, most of whom are going to return to our communities and most of whom are going to return and become safe and productive citizens, then we should encourage their participation in civic life and as voters, both while incarcerated and after release. But one of the things people don't know is people in jail, for the most part, are there because they were convicted of misdemeanors. That means everybody in jail who was convicted of a misdemeanor is an eligible voter. Only people convicted of felonies are disenfranchised, and most of those people are in state prison. There are a few in local jails, but a program that made sure that people in local jails can vote would be a huge positive benefit for enhanced rehabilitation and likelihood of a return to our communities in a positive light. So, I've heard so many people who are directly impacted by disenfranchisement talk about how important having the vote was to their becoming a productive citizen, and that it was really a basic building block for them. And it is a basic building block in democratic society. We need to think of voting in America not as a privilege, but as an entitlement. It is fundamental to our democracy. It needs to be treated as irrevocable. It shouldn't be seen as being something like a driver's license that's a privilege. The right to vote ought to be treated with the same respect as other fundamental rights in our democracy, like freedom of religion or freedom of speech. And as Professor Joshua Douglas said in the Cornell Journal article he wrote, the act of voting is perhaps the most politically expressive activity that any one individual can do in our democracy to have their voice heard. Voting shouldn't be a disposable tool for elected officials to use to decide who gets to choose them. Right to vote shouldn't be used at the whim of government to reward or deny benefits to or punish people. The ballot box should be open and accessible and not guarded as a sacred space only open to some. We must demand our right to vote on the constitutional amendment that would guarantee this fundamental right for all. And we need to oppose forcefully all of the efforts being made right now to return Virginia to a commonwealth that deprives people cavalierly of this most basic right. Thank you, and I'd be happy to take your questions.
The first one is from Dana Warman, and she's referring to something that you said early in your presentation about the redistricting. And her question is, can you explain more about the redistricting and why there are elections for state house 3 years in a row?
Yeah, the last time this happened in 1980, it was because one of the efforts that the legislature had made to avoid complying with the Voting Rights Act was that they had multi-member districts in a lot of parts of the state. So, for example, down in Patrick County, in that part of the state, there were 3 people elected at large for several counties in Southside, and those districts were designed to make it impossible for Black voters in those districts to be able to elect the representative of their choice. And so the 1980 redistricting plan that included multi-member districts was declared unconstitutional by a federal court, and the court ordered a new plan was developed and put in place, and the court ordered them to run in the new non-discriminatory plan in 82 and 83, because they had run in the discriminatory plan in 1981 before it was adjudicated to be unconstitutional. So the courts had an order to give Black voters their one person, one vote, and their right to elect a representative of their choosing. The House needed to run in the new districts before the next time they were scheduled to, which was 1983. So they had to run in, they ran in 81 in the old plan, they ran in 82 and 83 in the new plan. There is a lawsuit in federal court right now arguing that we're in the same place that we were then, which is to say the plan that existed before the census was discriminatory and not fully representative of one person, one vote because of the population shifts that had taken place between 2010 and 2020. And so when the House ran in 21 in the old districts, the existing pre-redistricting districts, they ran in districts that were not in compliance with the constitutional imperative of one person, one vote, because they weren't evenly balanced. The voters weren't evenly balanced among all the districts. And so the districts were unconstitutional. Plus, the other argument is that they had a disproportionate adverse impact on Black voters and their ability to elect the representatives of their choice. So the demand in the federal lawsuit that's pending is that they run in the new districts that were just approved in 2022, and then again when they were supposed to regularly run in 2023. And it really is all about assuring that the elections comply both with constitutional requirements with respect to minority voters, but also constitutional requirements with respect to one person, one vote. So we shall see. I mean, the lawsuit's been pending for quite a while. The NAACP just came out this past week and endorsed the lawsuit. The former Attorney General, Mark Herring, for reasons I don't fully understand, filed on the opposite side, saying they shouldn't have to run 3 times. They shouldn't have to run in the new districts, but that's where it stands. And so we'll find out. And part of the reason Virginia is in this weird place is we're one of 2 states in the country that has odd year elections. And so everybody else was doing their redistricting with the idea of influencing the districts for their 2022 elections. And timing wise, we don't get the census data fast enough after the decennial year to be able to influence the next odd year election. So this is not an unusual reality. And the census data, obviously, this time around were delayed beyond what was even usual for the past. So we're in this weird place because we have odd year elections in part and can't get things done by the first election following the census and redistricting. I hope that answers your question.
Yes, I think it does. Diana also had a follow-up question. She said that her state senator has changed and she's not sure when that changed and whom she should call, whom she should contact. Diana?
She still has the same senator. She won't have a new senator until the 2023 election when the senators run in the new districts. So in the case of the Senate, because they have 4-year terms, they're not going to be running again until 2023. So I would I'm in the same position, and I'm treating my senator now as my senator.
Okay. Esther Williams asked the question, once an individual has completed their prison sentence, why still in 2022 is the person still not allowed to vote? Their sentence is over. Life should be allowed to start anew.
I couldn't agree more, but our Constitution says that if you're convicted of a felony, you lose your right to vote permanently unless the governor chooses to give it back to you. And the only way to fix that and to implement the policy that you and I both advocate is to change the Constitution. And I have to tell you candidly, I have no idea what this governor is going to do in terms of restoration standards. I'm frankly concerned that he's going to roll the clock back and that we're going to see a return to people being treated differently in the restoration process based on what they were convicted of, and people being required to pay what I think is a poll tax by being required to pay their fines and fees and restitution before they can vote, which I think puts a financial limit on voting, which I think is tantamount to a poll tax. So, governor, I don't know what this governor is going to do with his power. So if we don't change the Constitution, we're going to be stuck with the whims of any particular governor for the foreseeable future.
The next question is, do any states now allow incarcerated individuals to vote? And do they have good ideas that we can borrow?
Maine and Vermont have no restrictions on voting for anyone. So they're the only two states that everybody gets to vote once they turn 18, and that right to vote stays intact, even if they get convicted of a crime and sent to prison or jail. There are many other states that have legislative restoration and other things. We're one of only two states that permanently disenfranchises, except for the governor's beneficence. Take a look at, if you go to the Brennan Center and you look at their report, Locked Out, which was published in 2020, that has a very comprehensive picture of all of the states.
Okay. Jody Goulden actually does not have a question, but she has a comment that I think you'll find very interesting. Her son served for a drug crime in the 1990s, and she became involved with a group working for those who had been convicted to mandatory minimums. What a happy day it was for him when he received his right to vote again.
That has been my experience of every person impacted by our disenfranchisement laws. There is a change in their posture when they get the notice that their right to vote has been restored. There is a change in the way they carry themselves in the world. It's you can see it on their faces and and basically in their body posture, that they've been restored to dignity and restored. I mean, these are people who paid taxes the whole time they're in prison. These are people who never lost their citizenship, but we've taken away from them the fundamental ticket for citizenship, the fundamental qualification for citizen, which is the right to vote. And we do so in a way that is, clearly based on an effort to disproportionately impact certain people.
Well, we celebrate with you as well, Jody. So thank you for sharing that. Carol Cochran asked, "What is the bill? The number of the bill, SJ what that we should call about?" Number one, SJ1.
And there's an accompanying implementation bill, which is Senate Bill 21, but SJ1 is, if that one doesn't pass, then the implementing bill is irrelevant. So.
Okay. And what is the website about citizen engagement?
The advocacy website is Boulder Advocacy. I mean, the good news is, because you've recorded this, all of my slides will be on the recorded record. And I'm probably going to post up the text of my comments and on my blog, but if you want to find me, and I'm happy to send the slides to anyone who really wants them. And I will, hang on a second, I'm trying to do something here, but share my screen. All right. I was going to try to put up my contact information here, but I don't seem to be able to get it going. Is it?
Well,
Claire,
your
this is
web-
Chris. We can put that in the next Encore Learning electronic newsletter so that anybody who wants it can have it.
Good. That sounds great.
And also through your website, right? changeservant.com.
Yeah, but there's the 10 tips for effective advocacy are on there in the bibliography at the bottom of my page. And there are connections to my blog there too. So if I put a bunch of stuff on a bunch of this will go up on my blog, so you can find it there as well.
Okay, perfect. Can you describe again the process that's needed to bring a constitutional amendment for voting in Virginia?
Sure.
And is it passing the bill for the governor's signature, or must it also be approved by voters? Roxanne
No,
wants
the way that you amend the Constitution of Virginia is a resolution is introduced in either house. It has to pass both houses in an odd year. So the current resolution passed both houses in 2021. There has to be an intervening General Assembly election. And then it has to be passed exactly the same. Not an I can be changed, the dot can't be taken off an I, a T can't be uncrossed. You can't make a single change. You have to pass exactly the same resolution in the second General Assembly session. And then it goes to the voters in the ensuing election. So if this resolution SJ1 was passed as it was presented to the Senate and passed by the Senate, and then if it were to get a vote in the House, it would go to the voters in fall of 2022. The governor does not have to sign. He has no role in this process. He doesn't have to approve it. He doesn't have to sign it. Obviously, if he sent a message to the House Republican leadership that he didn't like it and he didn't want to pass it, that would be something, but he doesn't sign the resolution, and there is an implementing bill that says what goes on the ballot, what is the question that's presented on the ballot. The governor can sign that bill and can send down amendments. When we were working on the 2006 resolution related to the marriage inequality amendment, the Marshall-Newman amendment, we worked really hard to try to get the question presented in the implementing bill in a way that would help people really understand what it did. And the governor did have to sign that, but the governor doesn't have to sign the resolution, and the governor can't keep it from going to the ballot if the House approves it.
This question, I don't think any of the bills involved people voting while they were in prison. Is that correct?
No, it is the law in Virginia that the only people who are disqualified from voting permanently are people convicted of felonies. So if you go down to the Arlington jail or the Alexandria City jail or the regional jails, most of the people in those facilities are there because they were convicted of misdemeanors. A person who was convicted of a misdemeanor does not lose their right to vote. And so I've, been actively encouraging all kinds of civic groups to take on the responsibility to go to the sheriffs who manage or the regional jail authorities and get them to agree to facilitate voting by people who are in jail. And in fact, there are some sheriffs in Virginia who are doing a good job of that and making sure that people who are in jail register to vote, get their absentee ballots, and actually can cast their ballots. And they are currently qualified to vote, and there's nothing that is happening that would take away that right from them. The only thing that keeps them from voting is a sheriff or a regional jail authority that does not actively facilitate voting.
And that's for people that have committed misdemeanors, not felonies.
Misdemeanors.
And where do they vote? Do they vote in the place that they're in prison, or do they vote in the district where they lived? They're not the same.
There's been legislation that seeks to address that by saying that people would be voting, would be counted for purposes of districting in their home precincts. And it is, the good news is that for the most part, because people convicted of misdemeanors are incarcerated in jail in their own localities, this isn't a big administrative problem. They vote at home. I mean, they vote absentee in Alexandria, you know, because they are in jail in Alexandria and they live in Alexandria. So they vote absentee, and there's a bunch of bills that will consolidate or redistribute the absentee ballots out. But the bottom line is most of the people obviously in jail, getting them registered is important because the average person spends about 30 days in jail. So they can miss the registration deadline if people don't actively help them get registered. That'll be less important with same-day registration. And then, you know, making sure that they get an absentee ballot if they're going to be in jail while the election takes place.
Thank you. Wendy asks, what are the arguments against requiring that voters present ID?
Well, the reality is that older people and people of color and people with disabilities disproportionately don't have quote unquote government issued IDs. So people who don't drive don't have a driver's license, and they don't often go down to the DMV and get a specific state ID. So they don't have a government issued ID. There are many people, particularly in rural areas, who were born outside of hospitals or institutions who don't have a birth certificate. And so getting government issued ID without a birth certificate can be a near insurmountable obstacle. Virginia requires you to show something that shows who you are and where you live. It's not that we don't require ID. The change that they're trying to make back, because we went this direction and now we went back and now they want to go there again. What happened was that we loosened up the ID requirements, so you could use like if you lived in a residence and had an ID card from that residence, you could use that, or you can use your gas bill together with something else that shows your identity. But when people want to try to make it hard for you to vote, then they want to put back in place this requirement for a single kind of photo ID, which is a quote government issued photo ID, and it has to be valid. So if you're 85 years old and you stopped driving 10 years ago and you still have your driver's license, you can't use that because it's not current. So, you know, the idea is not to say that nobody should have to show ID. The idea is to say people shouldn't be compelled to show only one kind of ID, which is a government issued photo ID.
Dick Sullivan asks, what is the relationship between federal and state legislation relative to voting rights?
Well, you know, we're trying to pass a federal law that would try to make voting more evenly available across all states. Federal law applies mostly to federal legislation. So, I mean, federal elections. So they can pass all kinds of laws that talk about federal elections, and then lots of times the state changes the state law to conform because it's just too hard to administer two very different sets of requirements. I mean, that happened when the federal constitution changed the voting age, and that was for federal elections, but most of the, all the states then changed the voting age. So the laws that they're trying to pass in Congress right now would go beyond that and would, like the Federal Voting Rights Act, use the power of the federal government to implement the 14th Amendment and other amendments to the Constitution to ensure that voting access is the same across the country, and that disparate efforts to suppress the vote aren't successful in some places and not in others. So it's our federal system is a little bit complicated, and it's not unusual for these arguments to end up sounding a lot like states' rights arguments when it comes to voting. But fundamentally, the state has complete control for the most part of state elections, and the federal government has complete control of federal elections, and then the federal government can go beyond that and exercise its supreme federal power in circumstances in which they're implementing the amendments to the Constitution.
Peggy asks, can you state in a few sentences the type of language we should use when contacting our representatives about the rollback of voter access laws?
Yeah, I think, you know, if you're contacting Senator Edmund and the members of the Senate Privileges and Elections Committee, you should say, please don't pass any law that repeals legislation that you enacted 2 years ago to increase access. You know, I just oppose any law that seeks to restore limitations on voting that you all voted, you know, to take away 2 years ago. And, you know, there are lots of different websites that have action links up. I know the ACLU has action links up on this. The League of Women Voters has action links up on this. There are lots of different people who are advocating around voting access, who Progress Virginia, who have, you know, forms that you can trigger with, you know, online if that's what you'd like to try to do.
Relative to that, you know, when we passed the amendment for redistricting, you know, with these new maps this year, One Virginia 2021 played a key role in that as an advocacy. Is there an organization like that that's taking the lead on it, or is there a lead organization on this cause?
On which the
voter,
constitutional
amendment? Yeah, constitutional amendment.
There's a coalition that includes the NAACP, ACLU, New Virginia Majority, and a host of other organizations. But they're, you know, and League of Women Voters is very actively engaged in supporting SJ1. So it's a coalition of a lot of different organizations. There's not one in the lead, and they didn't form a separate organization. Although if the House votes in favor of putting it on the ballot and it's on the ballot, there'll need to be a ballot committee that really takes on the campaign after that.
Okay. Jack Royer mentions, he says, I'm still confused about the 3 elections. This is for the delegates that you spoke about earlier. What happens to a delegate who is no longer in the district from which he was elected?
Well, nothing happens until there's a new election. I mean, right now, all of the delegates are in the districts that they're in until there's an election in the new districts. It's the same answer with respect to the senators. So if there aren't 3 elections, then you won't have an opportunity to vote for the election in the new district until 2023. And there are a whole lot of people who are going to have to sort some stuff out, because properly so, incumbent household residences was not a key factor in drawing election districts. So they're in Northern Virginia, particularly where the districts got smaller, you know, the geographic part of them got smaller because the populations were larger. There are places where there are 3 current delegates in the same district, and they're going to have to make decisions about, you know, how they're going to sort all that out. And, you know, that's part of the reason why none of them were particularly excited about the idea of having to run in 2022, because getting that sorted out between now and next fall is not going to be easy. It's not going to be easy to get it sorted out between now and 2023 either, but there'll be primaries, and they'll be in the new districts, and different people who are currently incumbents could be running against each other, or people may decide to move into other districts where they perceive themselves as having a greater opportunity. In Virginia, you have to live in the district to serve. You don't have to live there when you're running, but in order to serve, you have to live in the district. You have to be a registered voter in the district you're representing. That's in Congress, you don't have to live in the district. If you can get the voters, like Morgan Griffith doesn't live in the 9th district, but he got the voters in the 9th district to decide that he should be their representative. So there were different rules for Congress. But there are plenty of places across the Commonwealth where there are now more than one current delegate in a district, and then there are other districts that nobody lives in. So that'll all get sorted out either by 2022, if they're going to have to run in the new districts in 2022, or by 2023.
Eileen Janis asked the question, will you please speak about the issue of protection of absentee ballots? She said, I don't trust signature authentication as a way to prove validity, but I don't really understand how we can protect absentee ballots otherwise.
Well, I mean, there a lot of states do just fine with signature. I mean, heck, Oregon doesn't have, I mean, most of Oregon votes mail, so they don't have somebody standing in front of them to check IDs. And they figured out a way to validate signatures and to make sure that mailed ballots are valid. There are currently a couple of bills that would require you to put the last 4 digits of your social on an absentee ballot. There are some that I think are wrong-headed in mandating even more stringent witness requirements. But bottom line, I think we've had absentee ballots for a long time, and only recently have people started to perseverate about security. So I think signature validation, you have to file an application, and then they can check your signature on your ballot against your application, and that's one way they've been doing it. But as I said, there are a couple of bills in to suggest that you should have to put the last 4 digits of your social on your absentee ballot.
Gotcha. And I just had one final question. I was very surprised to see your listing of possible legislation to restrict voter rights, and all the press has been on Texas and Georgia for that. Do you think there's widespread awareness within Virginia about all these potential measures that could restrict our voting here in Virginia?
No, there isn't. And the same thing is going on with abortion and criminal law reform. So we made some major strides in reforming our criminal legal system, and almost every single one of them had a bill to repeal it. Introduced. A number of those, have been defeated on party line votes in the Virginia Senate, failed in committee by 1 vote, on a party line vote. And if the Senate hadn't killed a number of measures, they pretty much would be repealing almost every progressive criminal legal reform, voting rights, abortion rights measure that's passed in the last 2 to 3 years. And most people are completely unaware that wholesale retrenchment is going on in a circumstance in which the people doing the retrenching were elected by 1 or 2% of the vote. And saying things like the new Attorney General, when he filed a brief in the Supreme Court saying Virginia now believes that Roe versus Wade was wrongly decided. This is a man who won the Attorney General's office by, a percentage, and 1.7% or something like that. Who the heck is he to say he speaks for Virginia? When I was in the Attorney General's office, and Mary Sue Terry was my boss, and she filed an amicus brief in an abortion case that had to do with the rights of demonstrators versus the rights of people to be able to seek abortion unrestricted and without being harassed. She filed an amicus brief on one side of that case and said she was filing it under her own name as an individual Attorney General, not on behalf of the people of Virginia, because she said, I don't know, I can't represent the people of Virginia. There's not a majority point of view I could possibly see myself as representing. But Mr. Mieres seems to think that being elected by 1.7% means he can speak for all Virginians all the time. And so he's initially now filed a brief saying that Virginia thinks Roe versus Wade was wrongly decided and should be overturned. And he's also removed Virginia from a brief that was in a case that was intended to say that Virginia's ratification of the Equal Rights Amendment as the 38th state meant that the Equal Rights Amendment would become part of the Constitution. And I don't think that these, sort of radical revisionist efforts are being made known enough for most Virginians. I don't think that's what they intended when they voted. I don't think they intended to roll things back like that.
Well, obviously you've stirred the pot here among our participants, so we're thrilled. We really are, and it was very, very informative. One of the comments was very helpful and informative, and I think that represents all of us in this.
The right to vote should be the least partisan issue that we have. I mean, voting is the essential currency of democracy, and everybody should want everyone who is 18 and over and a Virginia resident and a citizen to be able to vote in Virginia. And the idea that we continue to debate that blows me away. It just shouldn't be a partisan issue.
Yeah, we have a lot of other fish to fry, so to speak. Let's, hopefully. Well, also, I wanted to remind everybody that we will be posting the slides, and this is being recorded. And Claire's website is changeservant.com. So there's a whole lot more on her website, and also you can get in touch with her with your further questions. So, Claire, thank you very much. How appropriate for you to be here on President's Day.
Thank you so much. I appreciated the invitation. I've enjoyed myself, and thanks for all the great questions.
Oh, great questions. I agree. So thank you, everybody. So we'll see you at the next Encore Learning event. Thank you.